Hello, everyone, and welcome to the installation of our Pocket Chat series supporting the Chicago Bar Association and the Chicago Bar Foundation's Sustainable Practice of Law and Innovations recommendations. I'm Lynn Grayson, co-chair of the task force, along with Justice Marianne Mason, and also the CBA's first vice president this year. I'm so happy to be here today with Mary Robinson, chair of the Regulating Technology-Based Legal Products and Services Committee of our task force, and one of the best known and highly regarded professional responsibility lawyers here in Illinois, and someone that I've known a long time and have a huge amount of respect for. So we're so happy that she's able to join us today. Mary was formerly the administrator of the Illinois Attorney Registration and Disciplinary Commission, and now is a partner at Robinson, Stewart, Montgomery, and Domke. During this chat, we're going to discuss recommendation number 2, modernize the rules so that lawyers can more actively participate in the development and authorize the delivery of the technology-based legal products and services by individuals or entities, and appoint a board to develop an appropriate regulatory mechanism responsible for registering and vetting approved legal technology providers. Mary, I think I've already mixed up a couple of those recommendations. We're actually going to talk about 2 recommendations. One is to, again, recommendation number 2A, modernize the rules so that lawyers can more actively participate in the development and delivery of technology-based products and services. And the second recommendation, 2B, explicitly authorize the delivery of technology-based legal products and services by individuals or entities, and appoint a board to develop an appropriate regulatory mechanism responsible for registering and vetting approved legal technology providers. These 2 recommendations were put forth by the Regulating Technology-Based Legal Products and Services Committee, which was comprised of legal professionals who work in a variety of practice settings and represent a variety of viewpoints. With that being said, Mary, I'd like to throw it to you and ask you if you can kind of help us understand what the problem is here and what these recommendations are intended to address. And we'll start with the first recommendation, 2A.
It sounds good. And thank you, Lynn, for this opportunity. It's been a real honor to participate in the task force. Wonderful people involved and really pressing issues for our times. The first recommendation that we're talking about really arises from the fact that the probably most significant development in the provision of legal services in our times is occurring with little or no participation by lawyers. Technology companies are making it possible for consumers to access legal information and solutions without actually bringing a lawyer into the mix, and consumers are eating it up. But under our current rules, the participation of lawyers is extremely limited, which I think is counterintuitive, both for purposes of consumer protection, which is what we are aiming to most address, and also it's just not good for lawyers. So what we're looking at really is that in our view, these services, the technology-based services, would be immeasurably more helpful to consumers if lawyers are directly involved in the design and the implementation of the systems. And it's very important for lawyers to be able to serve clients through this medium. Right now, our rules are, they complicate the involvement of lawyers, and our committee would like to see that expanded.
So you're absolutely right, Mary. These are extraordinary times that we're living in, and I think all of a sudden we realize how important technology is. So I think you have one of the most important committees on the task force, and your work is ever present and more important than it was before, you know, everything started the last 4 or 5 months. Given the work that your committee has undertaken, how does the recommendation and the work of your committee address the problem that you just outlined for us?
We start with a recommendation that would allow the lawyers to participate in what I'm going to describe as a one-to-many model. What technology allows or really facilitates is taking a problem that's reasonably simple, common, faced by multiple consumers, and where it's feasible, and it clearly is feasible for a lot of legal problems, technology can identify the common solutions and make those available. Under our present rules, you could call this a limited scope option. So I want a will. If I go to a lawyer's going to ask me about all my background and my desires, my family, whatever, and will explain different options to me. Well, I happen to have about nothing, okay? But it really matters to me to have a will, and I don't want to pay a lawyer, and I don't want to be embarrassed about the fact that I have nothing. But it really matters to me to make sure that the right children get their piece of my very small estate. And a lawyer is, under the present rules, could provide that limited scope, but only by telling me what I'm giving up. The lawyer has to figure out what the potential options are and then explain to me what I'm risking. So the technology solution really doesn't work with that model. What it does is it identifies, here's an option that many people want. And so what we're suggesting is that people get to choose that. And what we do is amend the limited scope rule 1.2, to allow for, only in the context of a technology, an approved provider, to allow for a more limited explanation, and really much more like, you get, what we're proposing is that the provider identify for the consumer, before taking any money or even providing any services, that there are limits on what's being offered, and if that's what the consumer wants, they get that. And one of the things that we have suggested is, and we'll talk about the regulatory model in a minute, but we're suggesting that the regulator approve the content of the disclaimer or the acknowledgement, because one size may not fit all. We didn't want to draft a rule that would purport to accomplish that, and we do see a lot of value in having this develop, and so it wouldn't be there would not be authorization of a mindless disclaimer that's buried somewhere in a website that's useless, right? We really want it to have meaning, but it would avoid a more in-depth consultation and large explanation, which seems very simple, but it's really different from what lawyers are used to, and what the rules really require of us.
Right. Well, and on that note, Mary, we've talked about this before. There's a dual purpose that is served by what your committee is proposing. It's more protection for legal consumers, but it's frankly an expansion and greater opportunities for Illinois lawyers to participate in what is already out there, these technology-based programs. So when I think about it, I think it's a win-win from both sides. It helps those in need of legal services, and it helps those that should be involved in the provision of legal services, namely our Illinois lawyers.
I totally agree, Lynn. I think that it's very important. Okay. And I can give you an example, because it's your next question, of what a lawyer could do.
That would be great. Thanks for helping me.
No, that's all right. One of the members of our committee was responsible for developing the Rentervention website. And one of the things that the website does is it allows somebody to enter certain information, a tenant who's facing an eviction, or another type of dispute with a landlord, and the tenant can put in discrete information and find letters that they can then use to send to the landlord. Now, a lawyer who regularly does eviction work could make that same service available to clients on the lawyer's website so that they can move into using legal services on a very contained, inexpensive basis. And then if they find themselves in desiring a more robust relationship, wow, there they are, right there with the lawyer who helped them get into the field and really access the power of law. I think that that's one reason people are not seeing lawyers. They do not understand the power that the law might give them in certain circumstances. And something like this would allow someone to get in gradually and establish a comfort level and really figure out what else they might want.
Right. I think we've learned over the last several months that technology is critical not only to operate our justice system and our courts, but increasingly people are looking for what I hesitate to call self-help options. But if lawyers are not a part of the solution, I think it's going to be a critical issue and a problem for consumers moving forward, just because we won't have any control and we won't be able to judge the appropriateness and the accuracy of products that are out there that Illinois consumers have access to potentially. So
exactly. No, I agree wholeheartedly.
So this is maybe a good place, unless there's anything else to add. You want to transition to recommendation number 2, talking about the technology-based products and kind of the next recommendation made by your committee.
Right.
And can you explain the problem like you did before and outline, what the issue is?
Right. One of the overarching concerns that the task force was asked to address is the great gulf between legal need and utilization of legal services. And our committee was asked to look at how technology could help bridge that gulf. And in getting there, we concluded any number of things. Why is the gulf there? One factor is obviously cost. Another is ease of access. And it's both from a comfort level and from just a familiarity and resources. I mean, somebody who isn't sure what they really need isn't loving the idea of taking a day off work to go see some lawyer in the Loop, and pay for parking and a babysitter and whatever. If instead at 10 o'clock at night, they can sit in their living room and access information and maybe even a product that would answer their issues, from their living room. So, obviously technology has great potential for addressing those causes and being realistic about it too, we recognize it's already there. We've already said this now a few times, but I'm going to keep saying it. It is there and people like it. Okay. And the problem right now is that there's no real regulatory mechanism for addressing it. Plus the rules keep lawyers out. So lawyers are scrambling for business. People are going elsewhere. And because of some of our structure, we're not regulating elsewhere, and lawyers can't participate without risking discipline. So our proposal is to try and address those structural difficulties so that we bring technology under the authority of the Illinois Supreme Court, which has authority to, for all purposes to regulate the practice of law. And we bring lawyers more into the technology provider sphere. So that's...
Mary, can you talk a little bit about the specifics of the recommendation that your committee is making and how that would work in Illinois?
Sure. First, we're proposing explicitly authorizing technology-based legal solutions. Right now, anybody's guess. Okay, it used to be just forms. We argued about whether that was the practice of law. I think that there's a lot of argument about whether or not, say, LegalZoom or operations like that involve the practice of law. And rather than continuing to argue about that, we say, call it the practice of law, but bring it under regulation. And so we are recommending that really this is as simple as adding a comment to the unauthorized practice of law rule and identifying an authorized service provider as authorized practice. Then we propose creating a regulatory body that would have the authority to oversee the technology-based providers. We also propose amending Rule 5.4. And this would be important for purposes, there's a great deal of argument in the profession about having non-lawyer ownership of law firms. Our committee has not taken that leap, and we found it much easier to deal with our project, our charge once we realized we could do something different. We are just talking about technology, and we are recommending that for an authorized technology provider, that lawyers can share ownership with non-lawyers. Now, ironically, our debate in the profession is always about letting non-lawyers in, okay? This debate is about letting lawyers in because the non-lawyers already own the entities. And indeed, anything major requires a significant investment of resources that very few lawyers would be able to do on their own. I mean, the big operations have big investment behind them. And that's just not going to work if we don't, I mean, that necessarily involves non-lawyers. And so we're proposing that the rules be amended so that with approved providers, lawyers can share ownership with non-lawyers.
And as you point out, Mary, I mean, it really can't work without an investment of capital. And the way to make that happen is to marry the non-lawyers and the lawyers together creates, perhaps the most opportunities for everyone.
Right. And I'll go back to what we were saying before. You really want lawyers involved in the design. One of the proposals in terms of how these entities should be regulated, there's not a group of rules that they're going to be subject to. But we recommend that the board be authorized to establish standards, and criteria have to include what you would call competence from the lawyer's perspective, and that is accuracy of the information that's being provided, the efficacy of the legal solutions that people are accessing. And lawyers have to be involved in designing that so that we know that the solutions are appropriate. We want that, but we also want another important piece that we're going to be recommending is that the entity has to have important confidentiality provisions that would protect attorney-client privilege, protect against external invasion, but also, and this one would be different, all right, than what's out there, preclude the providers from sharing data. Because most major internet operations share data, and that's how they make a lot of money. They mine it, right? They mine the data and they share it. And our proposal would recommend that not be allowed, because that would clearly invade a relationship that should not be invaded by marketing. But right now, there's nothing to prevent that. So in a way, I think that what we're hoping is that that the recommendations would make something that's already happening much more consumer protective and more rigorous and more robust because we can encourage lawyer involvement.
Mary, is there anything else that you'd like to share with us or anything else we should know about this recommendation and your thoughts on regulating these technology providers?
Yeah, the only thing I would add is that our committee was unanimous in believing that the regulatory function should have some flexibility. This is new. It is not something that we already know how to do completely. I mean, there's no doubt that we can establish criteria and have certain expectations and certainly fees, you know, that would support the regulatory operation. But we need, some of this we're going to be learning as we go. And I will say this, you know, and I have absolutely learned that lawyers are control freaks, okay? And it is our job to know what can happen and to structure rules and agreements that limit that. And I think this is one of those moments when we just have to take a deep breath and understand that we don't know everything we need to know, and we can't know everything we need to know to move forward. And the committee was very much dedicated to the hope that we can do this in a way that is careful about what needs to be determined and flexible about what we don't know.
Mary, I know on behalf of the task force, we're very excited to have an opportunity to present your committee's recommendations to the Illinois Supreme Court. And on that note, a public comment period, as you appreciate, is going to open very shortly that will give interested parties, lawyers, and others interested in the work of the task force an opportunity to comment either at a virtual hearing and or to submit written comments to us. And more information is going to follow in this pocket chat. But on behalf of the Chicago Bar Association and the Chicago Bar Foundation, we'd like to thank you for viewing our pocket chat and your interest in the work of the task force on the sustainable practice of law and innovation. Please visit the Chicago Bar Foundation website at chicagobarfoundation.org to learn more about the work of our task force and to see the recommendations soon to be submitted to our Illinois Supreme Court to modernize the rules of professional responsibility and conduct to make our legal market work better for everyone. We invite you to view additional pocket chats related to other task force recommendations, also available on the Chicago Bar Foundation website, and share your thoughts and feedback during the upcoming public comment period. We look forward to your participation. Thank you very much. Mary, thank you again. We appreciate all of your leadership in this area.
Thank you, Len.